Welcome back, folks. So the Supreme Court will soon hear one of its most high-profile gun cases in over a decade. This case is out of New York, and it is fundamental to who we are as a society. People who grant government power, not the other way around. You see the theme tonight? But in New York, like so many other states, the government makes you prove your need for a concealed carry license to carry a firearm. It's called may issue. Many states have it, as opposed to shall issue, which means providing you meet the legal requirements, the government shall, meaning must, grant you that permit. The reality is the Second Amendment is absolute. You shouldn't need to pay the government a fee or pass some test to exercise that right. And even worse, like in New York, leave the ultimate decision up to some gun-hating bureaucrat of whether you can exercise your right. That makes carrying a firearm in those states a privilege, not a right. And that's not only wrong, but I believe it's unconstitutional, and the Supreme Court is about to back me up on this. That's my prediction. The case is New York State Rifle and Pistol Association versus Bruen. The head of the state police is who Bruen is. Because the conservative makeup of the court, I think liberal states are now freaking out. Well, joining me now is the executive director for the NRA's Institute for Legislative Action, my friend Jason Ouimet. Jason, it's good to see you.
Grant, good to be with you as always.
Jason, you and I have talked about this case before. I mean, this case is really huge. The Second Amendment is either supported or really, I'm going to go out and say destroyed, because this is about carrying a gun outside your home. The Supreme Court has never taken this up. Sure. How big is this?
Yeah, sure. Without this, honestly, the Second Amendment might as well be rendered obsolete. This is enormous. Over a decade ago, the court heard the Heller decision, right? Just said that you had the fundamental individual right to own a firearm in your home for self-defense. This is going to go beyond that. This is going to say whether or not that right ceases at your front door or it's allowed to exist beyond that. And as you mentioned, of course, for you and I, it obviously does, because that's at the very core of the Second Amendment. You know, shall not be infringed. The right to keep and bear arms shall not be infringed. So that's what this is going to have. And that's the impact that this is going to have. And I can't imagine for the life of me, but we'll find out, that when the framers were putting the Constitution together, when they were writing the Second Amendment, that somehow they decided that your right to self-defense, George Washington's right to self-defense would cease at Mount Vernon or Thomas Jefferson at Monticello. I don't think any of that was what they had in mind. I think they clearly understood the right to keep and bear arms existed well beyond one's house.
Well, you know, some good news is the Heller decision, which was big, backs up many of the arguments for the NRA and gun owners and the New York State Rifle and Pistol Association, which I know the NRA has been working very closely with to move this case to the courts. If they rule in our favor that the Second Amendment is a right, not a privilege, this upends gun laws in many of these liberal states. 19 attorneys general have now filed amicus briefs in this case. You're up against a powerful force. What's your prediction?
Look, I hate to ever predict what one judge is going to do, let alone 9 in black robes on the Supreme Court. But I got to tell you, something that does give me a little bit of hope and a little bit of comfort in that space. When you hear somebody like Clarence Thomas say that it's extremely improbable that when the framers were crafting the Second Amendment, that they only believed your right to carry was going to be from your bedroom to the kitchen, for example, that gives me a lot of hope. And I am hopeful that when the judges take this up, that they will affirm and restore this right as we know it's supposed to be.
Look, we know, thanks to the NRA, that constitutional carry, which, as we passed here in Texas, says you can carry your firearm without a permit because it is a constitutional right, shall not be infringed means something. Constitutional carry, thanks to the NRA, is taken off across the country. Again, this is important to make sure that takes off in many of these liberal states that just hates guns, Jason.
Grant, you couldn't be more right, which is why honestly the NRA is really proud of the New York State Rifle and Pistol Association. They're our official affiliate in the state. We're proud of the plaintiffs for having the courage to step forward and do this. And the men and women of the NRA are proud to stand behind this. and eagerly will await the arguments on November 3rd and a decision in the spring. And yes, it's just another step, and we will continue to advance every bit of constitutional carry where we can. We began the year at 16 states having it. We got 21 states that have it right now, and we're going to keep right on marching.
Well, this is why, I'm such a supporter of the NRA, been involved with the organization for so long. This is where member dues goes, folks. If you want to know where your dues are going, you're getting things like this going to the Supreme Court. You're getting constitutional carry across the country. It is so important that there's a group like that fighting for our rights. Jason Ouimet, as always, a pleasure having you on the program tonight.
Grant, always good to be with you. Thanks so much for having me.
Absolutely.